Opinions vary. No, that was smooth. Goddamn water somewhere. Really? My bottle of water. That's going to be because wounding that's what's causing that.
All right. I can see it, everybody. All right, I'm going to call cause numbers 1450917, 1450918, 1450920, 1450921. All style, the state of Texas versus Ethan Couch. Mr. Couch, you are here because the juvenile court has transferred your case to this court. You understand?
Yes, Your Honor.
All right. The purpose of our session this morning is to give you certain conditions of community supervision that I want you to follow while you are in and under the jurisdiction of this court. You understand that?
Yes.
Now, you received similar terms and conditions of probation when you were in juvenile court. And these conditions that I'm going to give you will be consistent with your juvenile probation conditions. Basically, you are to commit no offenses against the laws of this state or any other state or of the United States. You are to avoid injurious or vicious habits, abstain from illegal use of controlled substances, marijuana, cannabinoids, or consumption of alcohol beverages. You are to avoid persons and places of disruptible or harmful character. When you're released, you are to report to Community Supervision and Corrections Department of Tarrant County, Texas, immediately following a hearing that we might have, and monthly thereafter, or as scheduled by the court or the community supervision officer. You are to permit the supervision officer to visit you at your home or elsewhere at any time. You are to work faithfully at suitable employment and furnish proof of employment to your supervision officer. You are to remain within this county or any other of the adjacent counties unless you get permission from your supervision officer or unless I authorize same. You understand that?
Yes, sir.
Okay. You are to notify the supervision officer of this county if your address or employment is changed within 5 days from the date of such change. You will be ordered to pay a supervision fee. You will be ordered to pay a Crime Stoppers fee. And you will be ordered to complete certain hours of community supervision. You are not to consume any alcohols, as I said, and you're not to refuse a breath, blood, urine, or field sobriety test as requested by a peace officer or the supervision officer. You're not to operate a motor vehicle. And I've had my Community Supervision and Corrections Department to do an assessment with you. Now, it hasn't been complete, and I'm going to have them to do an additional assessment. I want you to understand that. Your lawyers also want additional time to give me their recommendations on certain issues that I need to discuss with them. The state likewise is requesting additional time for recommendations that they wish to discuss. And I'm going to decide after I give them additional time whether or not I want you to spend additional time in the custody of the Sheriff's Department and the county jail. But until we make that decision, you will remain in the county jail at this time. I want you to understand that you're not getting out of jail today. And your lawyers are going to talk with you about that. Now, we have a couple other issues that I need to take up at this time.
Judge, just for purposes of the record, we do not object to any of the conditions you just imposed, the standard conditions of probation. I do want to say, for the record, so as not to waive anything later, we object to the manner in which this case or this matter was transferred to this court. It was transferred, there was one cause number in the juvenile court, one petition, one judgment adjudicating him delinquent. The state, by their action without any prior court order or authorization, filed this as 4 separate matters under the 4 cause numbers you called out. And just so we're clear, we object to there being 4 cause numbers, so we believe that there should be, those conditions are fine, but it should be imposed under 1. And so the court knows, we are exploring the procedural avenues available to us to figure out what remedy could be available to us to litigate this issue about the 4 cases. But I just wanted to make sure I objected to it on the record so no one could say we had somehow consented to it through our silence.
Very well, and I understand that. And you'd like to respond, Mr. Shaw? Because it's my understanding you filed these cases. Is that correct?
Yes, our office did file these cases. There are 4 offenses, 4 victims, so 4 offenses of intoxication manslaughter with an individual victim of each, all committed back in June of 2013. And it is our position that 4 cause numbers is appropriate because there are 4 separate offenses.
Very well. All right, what other matters we need to take up? Mr. Alpert?
Yes, Your Honor. The first matter I'd like to address with the Court's permission is there's an order outstanding titled An Order Regarding Discovery and Media Dissemination. The first part of the order is the Court represents and orders that the Michael Morton Act covers these proceedings and our discovery responsibilities. The State would ask the Court to reconsider that ruling because the Michael Morton Act, we believe, does not cover these proceedings. The offense date on this case was June 15, 2013. The enabling statute for the Michael Morton case says that it deals with offenses committed after January 1st, 2014. So while the State has been very vigorous in providing the defense with discovery of all documents we have in this case, we do not believe it's proper for the Court to apply the Michael Morton statute to these proceedings.
Your Honor, we agree that the conduct for which Mr. Couch was adjudicated delinquent occurred prior to the effective date of the Michael Morton Act. We also agree that the State has provided to us voluminous discovery from the date that started back in 2013 to now. I can't imagine there's anything in their possession that would be covered by the Michael Morton Act that we haven't been provided with. That being said, we do not have any objection to the Michael Morton Act language in that order being deleted.
Very well. It will be deleted.
Okay. Your Honor, the second part of this order deals, for practical purposes, we'll call it a gag order. Restricts the ability of the State and other parties to disseminate information. And our position is that this case is not pending trial. The trial happened some years ago. There is no scenario where this particular case, these 4 cases against Ethan Couch, will ever go before a jury. So there's been no record and there's been no delineation of the justification for the gag order in this particular case. We don't think the fact that there's been publicity, which no one denies, is a sufficient justification. And since the only fact finder there's going to be that's going to make determinations is this Court, the State's confident that this Court's not going to be affected by anything disseminated to the media. And we believe that the case authority says that, presumes against gag orders and prefers that if there's something that's done that the Court finds inappropriate or a violation of the canons of ethics, that it deal with it that way. So we would object to and ask the Court to likewise delete the order regarding media dissemination at this time.
Very well. Response?
Judge, first off, point out for the record that Mr. Couch's mother, Tanya Couch, is a defendant in a case in your court that I believe is pending review by the grand jury and could quite possibly face a jury someday. Given the intense, I would ask you to first off take judicial notice of the widespread and intense media coverage that both Ethan Couch's case and Tanya Couch's case have engendered in the last 3 years. And then based on...
I will take judicial notice of that,
and,
as well as today.
And based on that, we don't really take a position on the order you entered. I would notice it's a pretty circumspect order in that it basically instructs all of us to comply with the ethical rules about commentary outside of court. And with that being said, we take no additional position. We trust the court's entrust this matter to the court's jurisdiction.
Yes.
Or discretion, excuse me. I misspoke, jurisdiction.
Thank you, Mr. Wynn. Mr. Albert, the purpose of my order is, and I state in it that the parties are to make no extrajudicial statements or otherwise engage in conduct calculated to, in effect, try these proceedings in the media, all right, in violation of the disciplinary rules. Now, I don't expect either the state of Texas represented here, or the defense, to do anything that would violate Rule 307 of the Texas Disciplinary Rules of Professional Conduct, all right? What I'm concerned about is statements made to the press, interviews made to the press about opinions that either the state of Texas might have or that the defense might have. Now, I agree with you that I'm the only person that will make the decisions on the Eaton Couch case, but as been told and as everyone knows, I also have Tanya Couch. And Tanya Couch is a case that, even though it has not been indicted yet, could very well be indicted. And I think that both Ethan and his mother are intertwined. So anything that's said in the media concerning Ethan will, in effect, also refer to his mother. And since his mother does have a case in this court, and until I hear otherwise, where either the state has abandoned the indictment, I do want to keep this order in effect. I don't want anybody to make statements to the press. The press has full access to this court because we do have an open court. And so the press will be at any open court hearings that we have. I've allowed them to do that. I've allowed them to have cameras in court. But I don't want, and what I want to contain is, because I've seen it happen, not just in this case, but in other cases, where lawyers, be they for the state of Texas or for the defense, have a tendency to want to give their opinion on what they think the case and how the case should proceed. And I want to be careful about that because as everybody understands that people that are on trial in this court have a right to be presumed innocent until a jury makes a decision otherwise. So I don't want these opinions to go out. And that's the whole purpose of this, not to gag you from saying anything, but just I don't want discussions being made to the press about opinions or giving interviews, quite frankly. As far as the date, the time when we have public hearings, my court coordinator, I've already instructed her that she can give this information to the press because we are an open court. But that's my biggest concern. And that's why I want this order to remain in effect.
Okay. No, not our objection?
Yes. What else do we move on?
Your Honor, this morning we filed a pleading entitled Respondent Probationer's Motion to Seal Non-Public Contents of District Clerk's File. I will note that I did file it under all four cause numbers, even though I object to there being four causes in this matter, but to make sure that it covered all the documents transmitted, I filed it under all four, with that objection noted. Essentially, Judge, when the judge of the 323rd Judicial District Court, the designated juvenile court in Tarrant County, transferred probation to this court, it entered a order, and it's set out in our pleading. That order was entitled Amended Order Transferring the Probation Supervision to an Appropriate Adult District Court, and it was signed, I believe, on April 5th of 2016 by the 323rd. That order specifically directed the clerk of the 323rd to transmit to the clerk of this court, or at that time they didn't know it was this court, they just knew it was going to be a district court downtown, which you're referred to, I think, as the receiving court throughout Judge Medicos's order. It directed the clerk of his court to transmit to the receiving court a complete certified copy of the district clerk's file from the juvenile court. That district clerk's file from the juvenile court is subject to the restrictions of accessibility to information found in Chapter 58 of the Family Code. It's the Juvenile Justice Records provisions. And as you know, Your Honor, the general public is not able to go down to the clerk's office of the 323rd and look at information in the clerk's file. The statutes make it very clear the limited list of persons and entities who can obtain juvenile justice information and the conditions under which they can obtain it. When this case was transferred under the determinate sentencing scheme and in compliance with Section 54.051 D-1, so that's 54.051 open parenthesis D-1 close parenthesis. When the juvenile court entered its order, it specifically delineated in the order 4 documents that were to be made part of the receiving court's public file. And those 4 documents are the petition regarding a child engaged in delinquent conduct, which was originally filed September 11th of 2013, the grand jury approval of that petition, which was filed September 13th of 2013, the judgment for determinate and indeterminate sentencing without jury trial, which was signed April 11th of 2014, and fourth, the amended order itself transmitting the probation supervision to an appropriate adult district court, which was signed April 5th, 2016. We would submit to the court that Judge Minikos' order was specifically in compliance with Section 54.051 D-1 of the Family Code, and indeed that's what the Family Code requires. Judge Minikos' order also said that everything else transmitted was to be put in the non-public portion of the clerk's file. Now that we are here, we are asking you to give effect to Judge Minikos' order and to the Family Code, Section 54.051 D-1, and the general statutory scheme concerning juvenile records found in Chapter 58 by ordering the clerk of this court to seal those items in the clerk's file and make them non-accessible to anyone other than the people and entities specifically listed in Judge Minikos' order. And those people and entities are attorneys for the state, and by the way, in the order and in the Judge Minikos' order and in our motion and proposed order we've tendered to you, I've used the language he used, which is attorneys for the petitioner and or the state. I think that means the same entity, for lack of a better term. Attorneys for Mr. Couch, which at this time is obviously me and Mr. Brown. Attorneys for Mr. Couch's parents, and note that it's not for Mr. Couch's parents themselves, but attorneys representing them. Employees of Tarrant County Community Supervision and Corrections Department, so your probation department, and employees of the Texas Department of Criminal Justice. What we are asking you to do is to enter an order that limits access, that everything that is, except those 4 specific documents, no one may have access to that except that list of people and the court without a specific order from you. The proposed order I've drafted envisions that if someone thought they had a legal right to these documents or to view these documents, they could come and petition you and ask you for permission to do that. The order I've also asked you to enter and have asked for in our motion is that you order anyone who does obtain copies of those confidential juvenile documents under the code that we're asking you to seal, that they not disseminate them to anyone else or share them with anyone who's not on the list without a specific order from you. And specifically what I have in mind is if that a document was in there, let's say there was some sort of psychological evaluation in the clerk's file, and that generally happens in juvenile cases. They will have them a lot of times. We would ask that that not be attached to any pleading, disseminated to the media, disseminated to some other third-party entity, other than one of the people listed in the order without a specific order from you. And that's what we're asking for. And we believe that clearly the Family Code still governs these juvenile justice records, even though supervision of this juvenile adjudication of delinquency has been transferred to your court, there are still protections for the family code and the records, and that's evidenced by the specific language of section 54.051D1.
Well, let me just say this, and I'll get a response from the state. I'm not even certain I have all the records yet. You know, as of this morning, I got additional records. So the juvenile court has sent some records. Basically, the order transferring the case is over to this court. But as far as some additional orders, I haven't gotten them all yet. And the orders I got this morning, I haven't had a chance. The documents, not orders, but certain documents that I've gotten this morning, I haven't had a chance to read them all. But I want to hear from the state on this, and then I'll discuss it further.
There's no objection that what the family law code requires to be made in the public record as far as the district court. What I take issue with is his last statement, that we can't file pleadings that refer to documents or attach those documents as a reason why we're requesting something. You know, there's nothing that says, hey, Judge, we're going to ask for these conditions of probation, and here's part of the reason why. He referred to a psych exam, or it could be a notice that was filed, and we want to attach that as part of the pleading to show you why we want to do something. Well, we want to mark that as an exhibit with this court and offer that too. But if you believe what he says, or does what he's asking you to do, we can't do those things. And that exceeds what the family law says, and also exceeds what the Code of Criminal Procedure says, and the government code and every place else.
Mm-hmm. May I respond, Your Honor?
Yes, sir.
Judge, there's a simple procedural mechanism for that. They could refer you to a document in your file.
Yes.
If there's something and say, Judge, we ask you to consider this document filed on such and such date without going into the details. And if you think about it, attaching it to a pleading that's filed later, and by the way, this order specifically that I've proposed to you specifically says anything filed April 11th going forward in this court is filed in a normal course of business as part of the public record. We agree with that. Of course, you can completely backdoor all the protections for juvenile justice information if all we have to do is figure out some way to attach it to one of our pleadings and file it. So we would ask again that if we think there is some overwhelming need to attach a specific document to a pleading and that we can't find some way to accommodate section 54.051, that we can file a motion and we can have a hearing about it. And I think we can probably do that by asking you to review the document and then without talking about its contents in court until you've decided whether or not it can be publicly disclosed, we can discuss whether or not there's a need to file it or not. And we would just ask that we be given the opportunity to object to that. There could be all sorts of things in a juvenile justice file that are confidential for various reasons. And we ask that those things be protected in the spirit of the law, which clearly down in juvenile court, none of this could be filed and made public record.
Problem is, we're not in juvenile court anymore.
I'm sorry?
We're not in juvenile court anymore. He talks about the spirit of the law. Let's talk what the law actually says. It sets out the limits. He's asking you to go further.
Well, but you know what? This case is a hybrid case. Would you agree with me on that?
In a very limited circumstance that it came from the juvenile court.
Well, but there are also documents that were filed by the defense concerning some additional information that should not be released. Would you agree with me on that? Because, quite frankly, based upon the family code, if the defense makes you aware of certain documents, they cannot be used against them. Am I right about that?
As to the second part, as far as not being released to the public, I mean, these are all issues that will be addressed in open court. We're back here in 2 weeks or whenever the court says it.
Yes, I understand all that. All I'm saying is, would you agree with me that my assessment is correct, that if they present you with certain documents, these documents can't be used against...
We can't subsequently violate his probation and ask you to send him to prison. Not that we can't use them against him. That's not correct. So they can be used against him in the sense we're asking you to assess terms and conditions of probation. Mm-hmm. We're asking you to do certain things because of that. Because they're basically missions.
Objection, Your Honor, to the subject or anything else.
Okay. Well, we're going to get into the subject matter of it. But
we're going to be using those against him. So to say that we can't use them against him, I take issue with that part. Mm-hmm. We will do.
And Mr. Shaw?
Your Honor, there is There is a provision in the family code you're referring to about notice.
Right.
Also, the court's going to have to recognize that notice also requires an opportunity to act. So some things that may have been brought, that may be a possibility, then there may be some amount of notice about. We're not provided in such a way that there's an opportunity to act, and so it would be our position that those items can still be used in a later proceeding to revoke and for other purposes.
And that's all a fight for another day.
Right.
I mean, the big question is, first off, are you going to seal the juvenile justice file in our clerk's file so that it's clear no one has access to it except the specific list of persons and entities who are supposed to? And then the second issue is, are we going to allow parties from either side to just start attaching things out of that to pleadings to get them out into the public record?
Oh, I am going to seal the documents that we've received from the juvenile court. And I will tell both sides, if either side feels that these documents should be released or should be in the public domain, then I want y'all to file motions with me. And I'll look at those particular documents and decide if in fact that's true. All right? But basically, I have an order, as Mr. Wynn stated, from the juvenile court, basically stating that all documents transmitted by the clerk of the 323rd District Court pursuant to this amended order shall not be considered part of the public record of the district clerk for the receiving court, that being this court, and will be accessible only by the receiving court, the attorneys for the petitioner in our state, attorneys for the probationer and his parents, employees of the Texas County Community Supervision and Correction Department, and employees of the Texas Department of Criminal Justice. So I think it's very plain in here that you still have access to it, you still be able to look at it, and if you feel that it's important to be placed into an motion or into the public domain, then you just bring that matter up to me and then we'll discuss it at that time.
May I approach and tender you a hard copy of our proposed order?
Yes.
And I emailed this to all members of the prosecution team at about 1 a.m. today.
All right. Thank you. Is there anything else we need to discuss?
Yes, sir. The state has filed a motion for consecutive confinement as condition of probation.
I'm sorry?
We filed a motion asking you to send us into jail time under Section 13. And just we point out to the court that Family Law Section 54051, Section E, tells you that you shall place him on community supervision under Article 4212 Code of Criminal Procedure. Article 4212, Section 13 tells you that you shall, once you've granted probation, which you've done earlier, that you minimum of 120 days as a condition of probation. We're asking you to enforce that on all 4 cases and to stack it, as the law requires or allows you to do in the 303.
Judge, when?
We received a pretty lengthy brief that they filed this morning, and haven't had a chance to completely review it yet. And I anticipate we will file something in response at some point. But off the top of my head, 4212 Section 13B of the Code of Criminal Procedure says a judge, and I'm going to kind of emphasize the words that I think are important, a judge, quote, granting community supervision to a, quote, defendant convicted, end quote, of an offense under Section 4908 Penal Code shall require, and it says at least 120 days in jail as a condition. First off, this court has not, quote, granted community supervision to Ethan Couch in this case. This court has accepted a transfer of a previously granted probation under the determinate sentencing laws in the Family Code. That's different. Second, Mr. Couch, because he was a juvenile respondent is not a defendant. He is the respondent and the probationer. He is not a defendant. A defendant is a term used in a criminal prosecution of an adult, which gets me to my last point, which is that under our law, Mr. Couch has not been, quote, convicted of an offense under Section 4908. He was adjudicated delinquent under the Family Code for engaging in conduct that amounted to a violation of Section 4908. And if you look at the documents we were just talking about, the original petition, it's a petition asking that he be adjudicated delinquent, and it basically said he engaged in delinquent conduct, to wit, it lays out 4 paragraphs of intoxication manslaughter arising from one motor vehicle accident. You look at the judgment. The judgment says he is adjudicated delinquent for engaging in delinquent conduct, to wit, 4 paragraphs of intoxication manslaughter. Under the law, he has not been convicted of a felony. He is adjudicated delinquent. This is a strange hybrid offense under Texas law, and we believe that on the simple face of the statutory language, Article 4212, Section 13B does not apply. Now, with that being said, I believe that if, after you have received additional information, you retain authority to impose terms and conditions of probation you think are appropriate, and I believe that you have the authority to impose up to 180 days once, and I assume at some point we will have a discussion on another day about whether or not there's 4 cases or 1 case and whether or not you can, quote, instead of the juvenile court before.
All right, let's say your argument is correct. And basically under 13B, what 13B basically says is a judge granting community supervision to a defendant convicted of an offense under Section 4908, that being the intox manslaughter, shall require as a condition of community supervision that the defendant submit to a period of confinement of not less than 120 days, okay? Now, let's say, and I didn't grant him supervision, of course, it was transferred to me. So let's say you're right on that argument. Nobody has discussed 12A, which basically says that if a judge having jurisdiction of a felony case requires as a condition of community supervision that the defendant submit to a period of confinement in a county jail, the period of confinement may not exceed 180 days. So basically, instead of 120 days, which both sides are discussing now, I think if I agree with you, then I have the right to sentence Mr. Couch to 180 days, which is much more than 120. Am I wrong?
As I stated earlier, Judge, I believe that after you have received additional information, if you think it is appropriate, you may sentence Mr. Couch, I wouldn't even say sentence, you may impose a condition of community supervision on Mr. Couch that he serve anywhere from 0 to 180 days in the Tarrant County Jail.
Right. I think the only difference we're talking
I think you have the
here
authority to do that.
is that your argument is that it's mandated that I shall do this under 13B versus
But minimum.
12.
You can do 180.
I can do 180, that's right, but the minimum is, so I think the big argument, as I see it, is that your interpretation is that I shall, which means I must, give him at least 120 days. Is that your argument?
Yes, sir. Here's one thing I'll point out to you. The defense counsel agrees with you that Section 12A applies. Okay, well, first of all, he just told you he's not a convicted felon. This is not a felony case, and he's not a defendant. All those are words in Section 12.
Mm-hmm.
Well, then that doesn't apply, if you believe what he said earlier. But now he says it does. So you can't have it both ways. You can't not like part of the statute because you don't like what's going to happen to you, and adopt another part because it's favorable to you, even though the words are the same. He told you words are terms of art. Well, he is a defendant. It is a felony. And if all those things are true, then Section 13 applies. And the minimum is 120. Judge, certainly if you, in your discretion, want to sentence him to 180 days per case and stack it, we're agreeable with that. That's more than appropriate. All we said was the floor is 120, and we're asking you to follow that law.
Judge, I think I have to respond to this.
Yes, sir.
Section 12 does not say convict or grant. It says if a judge having jurisdiction of a felony case requires as a condition of community supervision that the defendant submit to a period of confinement in the county jail, the period of confinement may not exceed 180 days.
Right.
It doesn't say a judge granting, and it doesn't say to a defendant convicted of. Okay? I think that we'll probably make some kind of argument that he's still not a defendant, but I think you got a lot better case under Section 12, and frankly, when they use the term having jurisdiction of a felony case, I mean, we can make an argument this isn't really a felony case, it's a juvenile adjudication, but it's a lot closer. That fact that Section 12 says that illustrates how different Section 13A is and makes it clear 13A doesn't apply.
What's your thoughts on that, Mr. Welch?
Judge, he's saying two things out of the same mouth. I mean, he got people horsing around him. And what is it? Is he a defendant or not? Is he a convicted felon or is he not?
He's not a convicted felon.
Well, Judge, then he is. If you believe what he said, if you take everything he said, then at the end of the day, we have no reason to be here because you can't even send him a TDC.
We have no objection to this terminating right now.
Well, I'm sure they don't. But we do. You know?
If that's the state's position.
Well, that's his position. That's not ours. Our position is he's a convicted felon, he's an adult, he should be treated like one. This euthanasia...
Well, I don't think there's no question about that.
Well,
My question is whether I should go by 13B or 12A.
We're asking you that Section 13 applies.
You saying 13 applies?
Yes, sir. And that's the floor. That's just a minimum. I don't disagree.
Well, I understand that, but there's a big difference here. You know, if you're saying that 13 applies, that means that, as I read it, that a judge granting community supervision, it falls under that.
Yes, sir.
So the question is, did I grant him supervision?
As the way it's set up, yes. Because you just got through going over the terms and conditions of probation. If you weren't granting it, then why were you doing that?
Yeah. Well,
And I guess my answer to that is because it was transferred to you.
Let me hear from the juvenile lawyer over here, Mr.
It is a
Mr.
conviction.
Shaw. I'm sorry?
It's a conviction.
All right.
He's a felon. This process...
No, I'm talking about on 13A now. Did I?
I'm going to get to that.
All right, Rob.
He was charged in a juvenile court, which is a quasi-criminal court, with 4 offenses: intox manslaughter, 4 victims. Those charges were reviewed by a grand jury of Tarrant County. That grand jury found probable cause and recommended prosecution that included prosecution in the adult system. They approved that petition. In essence, it's been documented. That cause went through the process into juvenile court. It was tried, the burden of proof was beyond a reasonable doubt. Those charges were found to have been true by proof beyond a reasonable doubt. That judge placed him on probation, gave him a 10-year sentence, probated it for 10 years as to each of those offenses. Then Judge Minikos had a hearing just a few weeks ago, and in essence made a new decision that the respondent, who is now a defendant, should be an adult and should be treated as an adult. In an evidentiary hearing, made the decision to that the respondent, that this young man, Ethan Couch, your defendant, needed further supervision, should be treated as an adult and supervised by an adult court, and transferred this case to you. When that case got here, family code says you can dispose of it as if you were the original judge on it. As if he were being tried as an adult. Because he is here, he is an adult today. And those transferred offenses became felony convictions when you got them, and you just put him on probation today.
Thank you, Mr. Shaw.
Judge, we disagree
I understand.
with that. There's three ways a juvenile case can be
Very
resolved.
seldom have I heard defense lawyers and state lawyers agree on anything.
Shocking, isn't it?
Right.
There's three ways a juvenile case can be resolved. You have an indeterminate sentence. That's just in the juvenile adjudication, indeterminate sentence. It's over when the juvenile respondent turns 19, and that's it.
We've had that in this case, too.
Yes, we do. There are two paragraphs of it. That is not a felony conviction, except the legislature has clearly indicated that it can be considered a felony conviction for certain circumstances. Under certain circumstances, a juvenile adjudication like that, if the juvenile respondent was sent to TJJD, can be considered a conviction for purposes of enhancement of a subsequent felony offense under, I believe it's Chapter 12 of the Penal Code. And I think that's important because the legislature clearly knew how to say, we want a juvenile adjudication to be a felony conviction, because they said it there. Okay? It's not a felony conviction for purposes of probation eligibility, by the way. There's case law about that, which shows that it's not a conviction for all purposes just because they said it in that one place. The other extreme that the state chose not to pursue in this case is they could have petitioned Judge Boyd under Section 54.02 of the Family Code to waive juvenile jurisdiction, and the word in the code now is transfer Mr. Couch to adult court. And had they done that, and had she granted it, he would have been brought down here, indicted like any adult defendant would be, prosecuted like any adult defendant would be, and would have in fact been convicted of a felony. Again, the legislature has clearly established a means to get a juvenile who has committed this or is engaged in this conduct. The law provides a way to make that juvenile ultimately a convicted felon. And the legislature specifically told you how to do it. What happened in this case is neither of those. It's this intermediate step. He is adjudicated delinquent, like a non-determinate juvenile would be, but upon disposition, a determinate sentence was imposed upon him. That determinate sentence does not become a conviction. The legislature doesn't say anything about that. And I think it's important if you look at Section 53.045, Section C of the Family Code. It talks about when the judge or when the grand jury reviews the petition to approve it for determinate sentence. It says that the grand jury can review it and investigate like any other crime, but may not issue an indictment unless the child is transferred to a criminal court as provided by Section 54.02 of this code. In other words, the legislature specifically was cognizant of the idea that this petition approved by the grand jury might be an indictment, and they said you can't return an indictment there. If they wanted it to act as an indictment, they could have said so. And they chose not to. They go further. If you look in subsection D of that section, it talks about in very narrow circumstances, the petition approved by the grand jury could be considered an indictment, but it lays out the scenario where that happens. That's where the juvenile is given a determinate sentence, sent to TJJD, and then transferred to adult court, or to TDCJ. And then it's only for these limited circumstances. 152.00161C and 245.151C of the Human Resources Code. So they drew out a little narrow situation and said, okay, it can be an indictment. If it was an indictment, maybe it would be a conviction for those narrow circumstances. By delineating those narrow circumstances, under the rules of statutory construction, we know that they could have made this conviction if they wanted to, and they haven't. Because it's not a conviction, provisions in the Code of Criminal Procedure that deal with persons convicted of an offense don't apply to us. That's different than saying whether or not you have jurisdiction. You clearly have jurisdiction over this case, but your jurisdiction flows from the 323rd. It flows from that amended order of transfer. It flows from the family code.
I understand all that, but your argument basically is, I guess, that since it all began in juvenile court and it now has been transferred to felony court, that I still have to follow all the rules and regulations of juvenile court, and I don't believe I have to do that. I think now that this is in felony court, I look at it like that. That's the whole purpose of transferring it to felony court.
I would say my position is a little more nuanced than that. I think that you have the authority granted to you by the family code, which is arguably greater than the authority originally granted to the juvenile judge, but still more limited than if this case had originated in adult court. If they had sought transfer under 5402, and the term we used to always use was certified, but he was transferred. I think it's confusing because you talk about transfer in 5402 and then transfer in determinate sentence. But if he was certified as an adult, then it would be just like any other adult case. It's not. It is a different hybrid beast.
So you're saying, based upon your argument, that I can't give him any time?
I think that you
I think
you could probably give him 180 days, but as a lawyer, I'm going to reserve my right to dream up some objection to whether or not we are a defendant and whether or not it's a felony case.
All right.
But my honest opinion is you can probably give him the 180 days. I do not think you can give him 480-day sentences. I think you give him one.
All right. Anything else, Mr. Shaw?
Yes, Your Honor, and I will be brief.
Enlighten me, please.
I want to point out, under 54051 of the Family Code, D1 allows for a transfer to this court. D2 tells this court to place that person on probation under 4212 of the Code of Criminal Procedure. E2 tells you that not only do you get to put him on probation under 4212, but you get to revoke him as if he was an adult, as if you had exercised the jurisdiction over him originally.
Right.
All of that means Judge Menikos transferred him to an adult court. He is an adult. He should be treated like one.
Right. Okay.
Judge, and I guess just so we're clear, what E2 actually says is that if the person is placed on community supervision, violates a condition, the district court shall dispose of the violation of community supervision or probation as appropriate. And notice that in our order it says probation, not community supervision, because the juvenile court still uses the old nomenclature, not the new. In the same manner as if the court had originally exercised jurisdiction over the case. It doesn't say as if he's an adult. It says in the same manner as if the court had originally exercised jurisdiction over the case. And what we think that means is that you have the authority to revoke him as if you were the juvenile court, and that you could sentence him as if you were the juvenile court.
All right. Let me just ask Mr. Shaw and Mr. Welcher. Let me see if I can get you all together, okay? Because Mr. Welcher is arguing under 4212.13b. What I'm hearing from you is 3212 12A. So let's get together. Or can we get together as the
My
state?
answer is both apply. You could do either. The statute 3212-13B says you shall and sets a floor. 12A says you may and gives you a range.
Okay.
Our position is that you should follow 13B, but if you don't, you can still follow 12A.
You agree with that, Mr. Welcher?
I agree, we're asking for you to rule on section 13.
Then you don't agree with that.
Well, I agree, but I still want to rule.
All right. Well, a ruling you will get. And of course, whatever ruling I make today is, I'm going to also give you folks some additional time to convince me that I'm wrong or tell me something else that I might need as far as probationary term. And I think I want to give both sides 2 weeks to get that information to me. But in the meantime, I am going to make a ruling concerning Mr. Couch's jail time. All right, Mr. Couch, in 1450917, wherein the court has received the transfer on intoxication manslaughter, as a condition of your probation, the court's going to order that you submit to 180 days in a county jail. As to 1450918, wherein the court has received the transfer from the juvenile court and its intoxication manslaughter, the court's going to order 180 days in this case in the county jail. And this is going to be consecutive, so after the first 180 days, then the second 180 days will start. As to 1450920, having the court receiving this as a transfer from the juvenile court as a condition of your probation, in this case, the court's going to order that you spend 180 days in the county jail, and this also will be consecutive to the other 2 cases, meaning that you will serve that after you finish your first 2. And as to 1450921, the transfer to this court from the juvenile court as a condition of your probation, I'm going to order that you spend 180 days in this case. And this also will be consecutive, which means that after you spend 180 days in your other 3 cases, consecutively you will do this. That's going to be the order of the court. I'm going to recess at this time. I will reconvene in 2 weeks. I want you to get with my coordinator, and I will, after I hear from both sides and arguments on why I should not do what I just did. Of course, nothing I do is in stone, so I might reconsider.
Okay. And Judge, just so we're clear, I don't want to waive anything. We object for all the basis I previously stated, and we would ask that you consider anything we submit to you in writing in the interim before the next hearing as timely in making your decision.
Yes, well, Mr. Wynn. Thank you so much.
Thank you, Judge.
We're in recess. Yeah. Oh, here. Did you make me a meal?
Coming, Lloyd? We got viewing today.
Yeah. He should be at the second level right now. When I come back and get that's what they want. Yeah. Oh, yeah. Dude.
I asked her a question because I started to put file names and then I was like, it was already on here. So that meant I thought that was an ad, it was already directed to the ad. So I whited it out and then I asked her about it. So I was like, I'm confused. Did they add this after? Which it doesn't show account two. So anyway, I went ahead and added it, but she was like, don't enter anything in until afterwards when you talk to Latonya, Latonya's gonna go and do something, because it doesn't have count two. Can we edit it? I know, so really it's like not 50. It should come up with only one count, right? And then I just asked him.